going to be getting started in just a few minutes. At this time, I'd like to remind everyone to turn off any type of sound-making electronic devices so that oral arguments are not interrupted.
Except for pacemakers and hearing aids.
Except for, very good. We're about to get started. Counselor, are you ready?
Yes.
All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Welcome to the Arizona Court of Appeals. This is cause number CV120843, Trevia versus Blue Cross. Welcome. These proceedings are being recorded both audially and visually. Hopefully in a couple of weeks you'll be able to see yourselves on YouTube. So as you approach the podium, please identify yourself and who you are representing. You will each have 20 minutes to make your presentation. Appellant, you may reserve a portion of your time for rebuttal, and if you'll tell us how much time you would like to reserve, we will try not to horn in on your time. Okay. We have read the briefs. We have discussed the case in conference this morning. We've looked at relevant portions of the record, so we are familiar with the facts and the issues that are before us today. And the clock on the podium tells you how much time you've got. So with that in mind, you may begin.
Good morning. For the record, my name is Richard Treon. I represent the appellants. I will, since the court has obviously read the briefs and they're very extensive, not try to bore you by restating things that are in the brief. My intention is to basically summarize for you the important points that we believe require reversal and answer questions the court has, of course, and to then reserve my time for rebuttal. I imagine that will be approximately 10 minutes, depending upon how long it takes me to say what I have to say and whether or not you folks have any questions. Am I speaking loud enough, by the way?
Yes, you are.
Okay. I just got hearing aids, and I never know whether I'm talking loud enough, so anyhow. It's a plaintiff's appellant's position here, Your Honor, that the trial court just basically abdicated its responsibility as the trial court, and instead of following the teachings of Orem School versus Reeves, and instead of considering the evidence of record that indicates that a genuine issue of material fact exists on all four of the claims that we raised, the trial court just basically restated all of the statements that Blue Cross Blue Shield had put in its motion and never engaged whether or not there really was a genuine issue of material fact raised by the evidence that plaintiffs had proffered. With regard to the first claim, Blue Cross Blue Shield's position that despite the fact that their insurance contract with the Tavillas provided that there would be excluded from coverage any requirement to pay for Actic, the drug that they did pay for over a 4-year period because it was not approved by the FDA. And despite the fact the contract said that we will not pay for drug usage that is not approved by the FDA, nonetheless, because Blue Cross Blue Shield had failed to establish any kind of a rational pre-certification procedure or any other way to review the propriety of paying for a drug, they just paid for it. And they did so in a situation where it had consequences not only for them in paying for a drug they were not obligated legally to pay for, but it caused Mr. Tavilla to have to pay, on average, $450 per month of copays that were not copays he ever should have had to have paid. And over the course of the 4 years that we alleged conduct on the part of the police that breached the contract, Mr. Tavilla was out of pocket approximately $38,000, a little above $38,000 in copays. That defendant says, well, no harm, no foul, because we weren't obligated to pay for this, and in fact we paid for it. Doesn't mean we breached our contract because it had no consequences to you. What did have consequences? It required him to pay $38,000 he never should have had to pay. It caused his teeth to end up having an adverse effect from the Actic drug and to rot, and it caused him to become addicted to that medication. And those are all consequences resulting from Blue Cross Blue Shield's breaching its contract with its insured by paying for a drug it was not obligated to pay for, and it specifically told the insured in the contract, we're not going to pay for any drug that is not approved by the FDA. Mr. Tavilla was never a cancer patient. Mr. Tavilla never needed Actic to take care. Yes, sir.
Excuse me for interrupting.
Okay.
I assume these are all claims that you have made against the treating physician as well?
Not exclusively all the claims, but to get to the heart of the matter, yes, we sued Dr. Barnes after Blue Cross named him as a non-party in fault. Now,
Is he part of this litigation, this particular case, or is there a separate case?
Separate case, Your Honor.
What's the status of that?
It's pending before Judge Gama. No trial date yet set. But to get to the underlying point I suspect that Your Honor has on your mind, which is that, well, Blue Cross Blue Shield says this is really between the doctor and the patient. But it really isn't between the doctor and the patient. All the doctor does is prescribe the medication. Mr. Tavilla has a contract with Blue Cross Blue Shield that says that for medications that are covered, you will pay for those medications. His relationship with his doctor is totally separate from his relationship with his insurance company. He has a right to sue his doctor if his doctor does something wrong. But in this case, we're not saying that the conduct of Blue Cross Blue Shield had anything to do with what Dr. Barnes did or didn't do, because the issue has to be analyzed from the perspective of what did the insurance company do. What the insurance company did was violate its contract with Mr. Tavilla by paying for a drug that was excluded. And by doing that, it violated the contract. It has nothing to do with Dr. Barnes. Now, they want to say that this is really an issue between the doctor and the patient and we can't get involved in that. Well, they do get involved in that in all kinds of different ways, as we outlined in the brief, where they have the right to exclude or include as a benefit a particular drug, where they have the capability, as they did in this case in 2008 when Mr. Hogan came out with his affidavit and his testimony, that yes, we did go back and look at the history of Mr. Tavilla's medical condition. And although it was on our medical side of our company and not our pharmacy side of the company, we did discover that he had been taking this medication during 4 years when he did not have cancer or anything like cancer, and when he was not an eligible person for this drug. Now, what did they do as a result of that? They told Dr. Barnes, from now on, we're going to require pre-certification for all patients who get Actic. Yes, Mr. Tavilla, we're going to say to you, we'll work with you basically to help you to switch him to another medication. But by doing that, they acknowledged that all this time they had medical knowledge and information that we submit should have caused them to stop paying under this policy for this drug.
Mr. Treon, I'm interested in, I'm more interested actually in the argument that the care of the teeth was covered because those dental services were integral to other medical services that were covered.
Yes, Your Honor.
So I'd like you to address that if you could. Among other things, I'm wondering whether there are any cases interpreting this policy interpreting this language in Blue Cross or other carriers' policies, and I'd like to talk to you about the precise language of the coverage. First, do you know of any cases anywhere interpreting this language?
I do not, Your Honor.
Okay.
I do not know of any cases that interpret that language of that policy. I do know that Dr. Paul Francis, a neurosurgeon, gave an affidavit in this case that was totally ignored by the trial court, which says that integral to the medical services that Mr. Tavilla needs is he has to get his teeth fixed because his rotten teeth are preventing me from doing neurosurgery on his back and neck, which this patient needs. Mm-hmm. And on the language itself, it seems patent that it is covered. It should be covered.
The key language, I think, is in two sentences in this in the policy. The page I have is just labeled dental services integral to medical services. The first sentence says these dental services must be medically necessary and an integral part of a medical service that is covered, and that I understand is what you're saying with the affidavit of the neurosurgeon.
Right, Your Honor.
The next sentence says these dental services may either be part of the medical procedure, the covered procedure, or may be performed in conjunction with and made necessary solely because of the covered procedure. Do you think that second sentence that I read it sets out examples of what might be covered, or do you think by saying may either be part of the medical procedure or may be made necessary solely that those further define what an insured must show in order to gain coverage?
The may be made necessary by is the critical language from the plaintiff's point of view. Obviously, Dr. Francis, the neurosurgeon, didn't need to fix his teeth to do his back surgery. But before he could ever do surgery on that medical necessity that Mr. Tavilla had, Mr. Tavilla had to have his teeth fixed, which we argue fits right into that language. And in any event, under the testimony and the affidavit of Dr. Francis, it's covered by virtue of what his affidavit and what he says. He has to have his teeth fixed before I can do the surgery, and he needs the surgery. And that's incidental to the medical service. I can't make it any stronger than that.
Does the contemplated neurosurgery involve placement of plates or screws or other foreign objects?
Absolutely, Your Honor. All kinds of different medical, whatever's necessary. It's very serious surgery. Mr. Tavilla has, I don't want to go outside the record, but he has serious neurological issues that require major surgery and has for some time. It's both in his neck and in his lower back. And that's, Dr. Francis says it better than I ever could. I can't do this surgery with this guy in this condition with his teeth this bad, plainly stated. And so it is medically necessary, incidental to the surgery. And the teeth being fixed is incidental to the medical services that had to be provided. And I guess my point is that the genuine issue of material fact that was created by Dr. Francis's affidavit, which wasn't addressed by the trial court or by the defendant, they offered no affidavits. They had no neurosurgeon testify. They had no dentist testify. They had no addictionologist such as Dr. Sucher testify. The only thing that they had was Mr. Hogan, who himself creates an issue of fact with regard to the genuine issue of material fact on the question of bad faith by the insurance company for not responding to Mr. Tavilla in 2007 when he reported to them, this drug is causing my teeth to rot and I'm addicted to it, and I need help. And they don't do anything for him. But if you look at the timeline, when Hogan says that we really started looking at Actic as a possible drug to pre-certify in 2007, that's the same time Mr. Tavilla is bringing to their attention what's going on with him. But they just brush him aside and go forward with their investigation finally. And then in November 11, 2008, they come out with a letter to Dr. Barnes saying, we've looked at this situation with Mr. Tavilla, and yeah, guess what? And they even don't tell the accurate facts in that regard, because they say that he's been taking it since 2007 when their own records indicate he's been taking it since 2004, and we're no longer going to just pay for this drug. We are now in the future going to require to pre-certify. But under their policies and procedures that they had in place at that time, they had represented to the insured in the contract of insurance that we will evaluate these medications when they are prescribed, and we will reserve to ourselves the right to say whether or not they have a medical benefit, and we have a right to say whether or not we're going to pay for it. But they didn't do it in this case, and the reason they didn't do it is because apparently it hadn't reached critical mass in their statistic procedures that they have of keeping track of how much money they're paying on drugs, and or because Mr. Tavilla finally got in their face in 2007 and said, help me, I'm addicted to this drug, and you're paying for it, and my teeth are rotting, and I need coverage under this policy because of the dental services. I didn't give him any dental services. They didn't give him any relief from the situation, and it's our position that there's a genuine issue of material fact presented for the jury on that question, on all those questions, all four of them. I'll reserve my time.
Thank you. Counsel.
Please, Court, Jeff Collins on behalf of defendant Appley, Blue Cross Blue Shield of Arizona. With the exception, Your Honors, of the dental services benefit, plaintiff's entire case hinges upon a duty not recognized by any Arizona court, and as far as the parties can tell, a duty not recognized by any court nationwide. That is the duty of a health insurer to protect its insured from health care decisions made by health care providers and agreed to and followed by their patients, the insureds. They are asking the court to insert language into a policy which doesn't exist to find this duty, and they're asking the court to ignore the express language in the policy which precludes coverage for the dental services benefit, which I'll address shortly, all while continuing to rely upon irrelevant facts, impermissible expert opinions, and a total lack of case law to support the positions under either the Actique prescription or the interpretation of the contract that they're advancing for the court. Judge Flores correctly interpreted the contract like courts do, not expert witnesses, and properly upheld or granted summary judgment in favor of my client, and we respectfully request this court affirm her ruling. Really two major components of this case, Your Honors. First, the alleged breach of contract with regard to the Actique prescription, and secondarily with regard to the dental services, and I'd like to address them separately at this time. With regard to the Actique, that claim is not supported by any contract language whatsoever, and again, it's not supported by any duty recognized by a court flowing from such a contract. And finally, it's a complete misinterpretation or misapprehension of the insurer-insured relationship as a whole. Appellants say in their opening brief, and this is the duty that they argue for on page 16 of the opening brief, quote, defendant's duty under the contract was to protect its customer as it had impliedly promised to do in the benefits booklet and refused to pay for the drug, end quote. To begin with, this is a direct admission that there's no express promise in the contract. Now they're talking about an implied promise, and they still don't cite any particular language in the contract giving rise to this implied promise.
What would you call that in classical contract language? What would Corbin call that? Would he call it a reservation of right by Blue Cross to refrain from paying or it's,
I'm-
what would you call it?
Sorry, Your Honor, I apologize for interrupting. I'm not sure what I would call it technically, but really, if you look at the global picture of the relationship, insurers pay benefits, and as part of the benefits dictated by the contract, they're entitled to calculate risk and set premiums, and by doing so, set forth certain eligibility requirements and exclusions in the contract. And that's really to their benefit to calculate risk and apply the appropriate benefits to their insureds. It's not to say if you provide more to the benefit of a patient that we're liable for something that happens. And if you think about it, Judge Johnson, if you take it, and I don't think this is taking it too far, I can imagine a circumstance where there's a really close coverage call and the insurer gives the benefit of the doubt on the coverage decision to the insured in a health insurance situation. And they go ahead and they get the health care pursuant to that coverage and something goes wrong. It will be absurd for the insured to then come back and say, you're liable because you gave me the benefit of the doubt for the coverage for the care that caused me harm. That's really what they're asking this court to do. And again, there's probably a reason no court has done it because it doesn't make sense.
Let me recast the issue a little bit. And as I understand this insurance contract, Blue Cross Blue Shield reserved for itself the ability to require pre-certification for covered medication. And at some point in time, Blue Cross and Blue Shield elected to implement pre-certification for this drug. Is the timing decision by Blue Cross actionable?
I don't think so, Judge Winthrop. I don't know.
I mean, isn't that what they're really arguing here? Is that Blue Cross made the decision to require pre-certification, but they did not make it in a timely fashion, and the plaintiff was injured as a result, in their view.
I think, Judge, you take it one step further and say, what are the ramifications of that? Pre-certification isn't put in place to monitor health care. What they're arguing is you waited too long to insert pre-certification on this drug, and had you done it earlier, you would have been able to monitor my client's health care. That's not what pre-certification is there for. Pre-certification is there so that the insurer can manage risk and make the appropriate adjustments with regard to premiums, deductibles, and so forth. So the big picture still remains that.
Yes, but it has a collateral benefit for the patients.
Well, but you're assuming then that had they required pre-certification, that they would have stopped paying for it. But that's still not their overall responsibility, Your Honor. It's not their duty. That doesn't flow from anywhere to make eligibility or pre-certification requirements to prevent care. And in fact, all throughout the book that I cited in the record, it says that these decisions with regard to medical necessity, pre-certification, do not impact the relationship between you and the patient, that healthcare decisions are between those two, and these are simply eligibility or contract requirements.
Your argument is that's a reservation of right for the benefit, that's a reservation of authority by Blue Cross for its own benefit, not an obligation by Blue Cross for the benefit of the insured.
Absolutely, Your Honor. And it's entirely their right to do so, to calculate risk and so forth. I mean, it's the big picture here is it's not for the protection of the insured for care he or she receives from a health care provider or prescription medication prescribed by a pain management specialist and voluntarily taken by the patient. That's just not its purpose. And that's the big picture that has always been the big picture throughout this matter in large part why Judge Flores granted summary judgment.
Any cases anywhere addressing this argument?
No, Your Honor, no. Not that we're aware of.
What about the integral to medical services?
Sure.
coverage?
And again, briefly, they've continued to cite to doctors to interpret these contracts, and that's impermissible expert opinion. Doctors don't interpret insurance contracts, judges do, and Judge Flores did so, and this court will do so as well. And if you read, and you start with the language, and the language is clear and unambiguous, and it says that the dental services must be part of the procedure or may be performed in conjunction with, and this is important, and made necessary solely because of the medical procedure. Okay, so it's an or, so it's two. Is it part of the medical procedure? No. The only thing that they've attempted to do there is say that Dr. Poulos, the dentist, feels the care is necessary to prevent effects throughout the body, systemic problems such as cardiovascular disease, diabetes, etc. That's not part of the procedure. That's not integral to a procedure. That's preventative dental hygiene to prevent care down the road. And if you think about it, this is a health policy. This is a medical policy, not a dental policy. If that was a reason to get dental care under your medical policy, there would be no dental coverage ever necessary.
According to
isn't
my
the,
dentist, yeah.
But isn't the medical procedure here the contemplated neurosurgery?
Well, allegedly, Your Honor, but as Judge Flores noted, there is no definitive evidence in the record of a particular procedure recommended, a particular procedure required, and what exactly is there. The record is void of any of that evidence. And Your Honor, even if you think that has some persuasive effect with you, as I'd mentioned, the necessary solely provision of that is very important. In conjunction with and made necessary solely because of the procedure.
So just so I understand, because I was having this conversation with Mr. Treon, and I'll obviously go back and look at the Dr. Francis affidavit, but isn't there evidence in the record that there's a specific neurosurgical procedure that's been recommended, and as part of that procedure, which requires the placement of hardware, that it is critical that an existing infection be eliminated from the body before that surgery can be safely performed?
Your Honor, obviously the record speaks for itself. I don't think it's that strong, and I think with regard to Dr. Francis, it was a supplemental disclosure statement, and I don't know that there was a particular procedure. Dr. Francis says vaguely that he's needed, in the disclosure statement, that he's needed this procedure, dating back to the 1990s. But again, the most important part of this is necessary solely
But back up. What's the verb in that sentence? These dental services may either be part of the medical procedure or may be performed. I mean, one way of reading that is that's a sentence that gives examples of, mere examples of dental services that are medically necessary and an integral part of a covered procedure, right?
Well, there's no particular examples there. It's either part of or it's in conjunction with something necessary. And I have some examples for Your Honor.
But my question goes to maybe this or maybe that. I think you're reading it, and you did say it actually, must be this or must be that. And if it's not one or the other, in your view, it's not covered. I'm just suggesting another way of reading that sentence, which is that maybe this or maybe that is a sentence that provides examples of integral services.
Right, but it still must be integral to medical services.
Right, absolutely.
Right. And again, if I can briefly, the second part of it is really the most important, and plaintiff's appellant's own evidence contradicts it. Made necessary solely because of the procedure. In 2007, when the dentist set forth the dental plan, that was for, quote, long-standing decay, end quote, and severe dental breakdown, end quote. That was the basis that this claim was presented to my client back in 2007. Nothing about part of a medical procedure. And again, Dr. Poulos, who did submit an affidavit, says that the care is necessary to prevent other problems throughout the body. Those are two other reasons, independent reasons of anything Dr. Francis may say in a disclosure statement or affidavit that directly contradicts the unambiguous language made necessary solely because of a procedure. And the examples, to put this in context, Your Honors, for radiation therapy, for neck or jaw cancer, it's necessary for tooth extraction. That's in conjunction with and made necessary solely because of a medical procedure. The radiation, you have to extract the teeth. Part of a medical procedure is the repair or removal of teeth during jaw surgery. Those are part of or made necessary solely because of long-standing dental decay, long-standing dental breakdown, and to prevent future problems, as comes from their own expert in affidavit, totally defeats it right there based upon the made solely provision of that requirement. I don't think there's any question that this wasn't a result of accidental injury. I think the language there is clear and unambiguous, and Mr. Treon really hasn't argued that.
Doesn't mean unintended, it means really accidental.
Correct.
Yeah.
And I think that if injury to a tooth while chewing is not considered accidental, then certainly using a lollipop lozenge is not accidental, and I think that's clear based upon the language of the contract there. Just briefly back to the Actique prescription. Their argument ignores the fundamental purpose of health insurance, which is to pay for benefits. The principles are communicated in the contract throughout that, we're not making healthcare decisions, we're not getting in the middle of you and your doctor, and furthermore, ARS 2836 supports this fact in that companies like my client cannot be liable for the healthcare decisions made by doctors providing healthcare. With regard to the insurance bad faith issue, this is a coverage decision as it relates to the dental services. If the coverage decision was proper, then it was clearly fairly debatable and reasonable, and that would preclude any bad faith decision, or bad faith ruling based upon the coverage decision itself. There are no allegations independent of the actual coverage decision in the record that somehow the claim was handled improperly, or certainly that it was done intentionally or with conscious disregard to cause my client Mr. Tavia some kind of harm. So I think in this case, it so clearly comes down to the coverage decision that there can't be any bad faith should you uphold Judge Flores' ruling. And more importantly, even if for some reason you don't, it's clearly debatable and a reasonable conclusion based upon the facts as known and the express language of the contract as interpreted by the courts and not plaintiffs' experts. Unless there are any further questions, my client would respectfully request that you uphold Judge Flores' decision and affirm summary judgment for my client.
One more question. I'd like to ask, are there any cases interpreting the integral to medical services provision of this contract?
Not that we're aware of, Judge Johnson.
Okay,
Thank you
so much.
Speaking first to the question of Dr. Francis and what he said in his affidavit, that's actually located at page 10 of our reply brief. And it has, of course, to do with this issue of whether or not the necessity for dental service was incidental to the necessity for medical services. And what Dr. Francis says is Mr. Tavilla's severe periodontal disease required curative dental treatment, then immediately necessary prior to any surgical procedure, both because pre-surgical clearance would require Mr. Tavilla's teeth to be fully treated and infections eliminated due to the increased risk of postoperative infection and or sepsis from infections in the mouth, which in turn would increase the risk of failure of hardware and grafts or death from overwhelming infections, as well as potential complications, etc. So Dr. Francis directly addressed that issue, and he says it was medically necessary for Mr. Tavilla to have his teeth fixed before I could do the medical necessary neurosurgical procedures that this man needed. And the fact he needed them since the 1990s doesn't take away from the fact that he needed it then, and that's what Dr. Francis said. Justice Johnson, going to your question about whether or not under Corbin it would be a reservation of rights type provision, is our position is stronger than a reservation of rights issue. It is a provision in the policy that specifically excludes payment. And direct your attention to page 7 of our brief, where it states the following, this is from the policy, describes benefits and limitations available to you for a prescription medication obtained through a retail or mail order pharmacy. He got his retail. It says a prescription is eligible coverage when approved by the U.S. Food and Drug Administration for the diagnosis for which the medication has been prescribed. And then we set forth the evidence from the FDA and Actique itself, the package insert indicating this is a drug of last resort. This is a drug for people who are dying of cancer who don't care if their teeth rot. They don't care if they get 2 grams of sugar in their mouth every time they put it in there because it takes away the pain. Mr. Tavilla was never in that situation. And going to the question of whether or not, so the point is, it's more fundamental than Williston or Corbin. It's Contracts 101. It's you make a promise to somebody you will do or not do something, and you don't do it, or you do it, and you breach it, and you cause damage, and that's called breach of contract. And they breached their contract with Mr. Tavilla by basically failing to do what they said they would do in the contract. And so that would be our response to that point. The other issue that was raised Judge Winthrop was regarding the right, whether or not the failure to act timely is actually at the heart of the claim here, and regarding the pre-certification. And it is in two respects. One, because that's what they contracted they would do back in 2004 when they first started to pay for Mr. Tavilla's ACTIC based on the contract he then and there had existing, which the contract itself provided that they would do that. They would identify at the beginning what level you're going to be at for potential pre-certification, and they would automatically put drugs at the 3 or 4 level without going in to analyze whether or not they should be at the 1 or 2 level, where it's a lot cheaper to the patient for copays. And they put Zactic at the high level of a 4 because they know that it's probably a drug they're going to have to pre-certify someday. But then they don't pay any attention to it until Mr. Tavilla in 2007, I think, the evidence could support that that's when they woke up to the fact that they had a problem here, or they knew they had a problem all along. And the whole thing is so counterintuitive to me. They're paying this money like crazy. The 3 cases he cited at page 16 are all cases where insurance companies refused to pay for ACTIC, and the courts upheld them because they had no obligation to pay it. So why do they keep paying for this very, very expensive drug for a man who tells them it's ruining my teeth, it's causing me to become addicted, except out of just failure to take any action or just too busy doing other things, or who knows what their excuse is. But Mr. Hogan, when he came back with his affidavit, admitted they knew this all along. In his testimony, he admitted that they could have found out clear back to 2004 by just looking at the metavalence side of their computer to see that, my gosh, this guy doesn't have cancer. This guy has back pain and myofasciitis and et cetera. I forgot the precise diagnoses. But go back to your point, yes, in terms of the issue of pre-certification, it is an issue of timing, but it's not an issue of timing just pops up in 2007. It's an issue of timing that was there from day one. Because day one, they contracted that they would review each drug that came in and that we will not pay for drugs that are excluded. And of course they want that provision in their policy because they don't want to pay if they can avoid it. But for whatever reason, and they never have explained why or how it happened here, they kept paying for this drug.
But is that a commitment they made as opposed to a right they reserved to themselves?
Well, if it's a right that they reserve to themselves, then when they know there are consequences, then they have to address the issue of whether or not they have some good faith obligation to the insured at that point to do something about the fact that if they have in fact reserved a right to themselves. I mean, and again, I go back to argue against that point. How can they sort of silently reserve this right to themselves after they say in the contract that we will not pay for drugs that are not approved by the FDA? It's almost, in a sense, a fraud case. It's a misrepresentation situation, because if Mr. Tavilla reads his policy, he says that I don't have to worry about it. I'm with a great company, Blue Cross Blue Shield, who's only going to pay if the FDA says it's okay. They go ahead and pay. He has a right to rely upon that. So they can't reserve unto themselves knowledge that they have that's peculiar to them in a specialized industry, while they're insured, while their customer is basically suffering detriment as a result of it. And certainly by 2007, there's liability here on the part of Blue Cross Blue Shield because it was brought right to their attention at that point in time, and they totally ignored Mr. Tavilla and never offered him any assistance. They didn't send a letter to Dr. Barnes saying, this is not medically necessary. We're going to do pre-certification from now on. You need to deal with the situation. They just basically abandoned their patient. They reached a covenant of good faith and fair dealing. They breached a contract.
But if, let's say that they had done the pre-certification. They had said you have to have it pre-certified, and they had, and Blue Cross Blue Shield had said, go ahead, Mr. Tavilla, go ahead and take it. We're going to give it to you off-label, I guess is what the term is. Would you still have the same argument? And doesn't that really go to what Judge Winthrop was arguing, that it's a right that they have reserved for themselves and not an obligation to your client?
Well, is your question then, if they had told Mr. Tavilla along the way, we are now going to require this to be pre-certified, you're our customer, you need to know that this is not an appropriate use out of the contract, and we're not going to pay for it anymore? Is that?
Well, a lot of times, even when they require pre-certification, they'll say, the doctor, I know this, you write, the doctor writes a letter and says, this is why we're using it. This has been the most effective way of controlling his pain. and we want to continue to use it for that purpose. And so if they had done the pre-certification, said you've got to pre-certify it, and we're going to allow you to use it off-label, would you still have the same argument? I mean, isn't your argument really that they didn't save him from his doctor?
Not to overstay my welcome, but Your Honor just said something that's not in the record. I don't know that. Judge Flores made the same mistake. She decided what some doctor might say with respect to what off-label means. We don't know what off-label means on this record. And under the evidence in this case, they breached their contract and they should be held liable. Thanks.
Thank you very much. Thank you both for your arguments. We will take this matter under advisement and issue a ruling in due course. Thank you very much.
Thank you.
Thank you.
See you, Dave.
Thanks, Jeff.